welcome back. So this week we continue our discussion of the standard of review. This is in fact the last portion on the standard of review that we'll have for this course. Concludes the chapter we started 2 weeks ago looking at reasonableness, correctness, and this week we have kind of a more historical context which I think will help us understand a bit more the nature of reasonableness review, and also the things that we saw either last week or 2 weeks ago on the specific factors, right? So the 5 things that are specifically excluded under Vavilov from reasonableness review, right? That list being exhaustive, everything else is subject to reasonableness review. And the 14 or so factors that we saw on what are the factual and legal constraints bearing upon a decision maker, right? Which are the way in which you assess reasonableness. So reasonableness means it's consistent with the factual and legal constraints. So the 14 or so things that we saw are ways in which you can have an unreasonable decision based upon the factual and legal constraints bearing upon the decision maker. We'll also look a bit more this week at the standard of review upon appeal, which is something that we discussed last week, right? Extremely important. We said if there is the magic word appeal, specifically, right, there's a million ways in which you can limit judicial review, in which you can show an intent on the part of the government to limit judicial review, to limit review in some way of the decision, and that will be an intent for deference to be owed, for all the reasons that we said. However, there is a very specific issue where you have the word appeal being used, not review, right? Not final decision, not unreviewable decision, but when you have the specific word appeal being used, and that is in the positive context. So if it says final and without appeal, that might suggest something else. But if it says you have a right of appeal, again, with the specific word appeal, then it displaces the entirety of the framework that we saw with reasonableness and correctness review. Entirely. So it's no longer a matter of reasonableness and correctness, and in fact it will be reviewed as our actual appeals, before actual courts, and we'll see that in the housing case, which we talked about last week, but which we'll have in a bit more detail this week. So to the extent that that word's being used, you're subject to that standard. Usually that standard will be, or actually almost always, that standard will be more demanding. And we saw the reasons for that last week, right? We said under reasonableness review, almost everything is subject to reasonableness review. That includes questions of fact, issues of fact, which are by default, even before the actual court, subject to deference. Issues of mixed fact and law, usually the same thing, but also issues of law, which are under the housing framework subject to correctness review. That's not the case under administrative law. In fact, issues of law generally are subject to the presumption of reasonableness review anyway, and that's going to be true, as we'll see, in the majority of instances, and that's because in the majority of instances, the decision maker will be interpreting what we call under the case law their home statute. So the statute by which generally they are constituted, the statute that gives them their power, and the statute that they are specifically tasked with applying every day. And to the extent that they're applying that statute or interpreting that statute, we'll assume that that's within their expertise, right? Because they were created precisely for applying that statute. Therefore, most issues of law will count as just that, right? Most issues of law, when you go before a court upon judicial review and you say this was done wrong, right? The administrative decision maker has made a mistake, right? Has improperly interpreted the law. Most often the law at issue, for obvious reasons, will be the home statute, the constitutive statute, and to the extent that that's the case, there's a presumption of reasonableness review, and in fact, it's a factor that says it is strengthened as it is for, say, discretionary decisions because they're interpreting their home statute. Any other law will also, by default, right, fall under the presumptive standard of reasonableness review, so that issue of law will be reviewed pursuant to that standard. As we saw, it's only when you fall under a specific exception, which is issues of law of central importance to the legal system as a whole, right? So not just any issue of law, it has to be really important, and on top of that, it has to have broader significance pursuant to the framework that we saw, which will generally mean significance beyond the instant case. So for that reason, right, most issues of law, which are the thing that are typically subject to correctness review before an actual court, will be under administrative law still subject to reasonableness review. That is why the word appeal is important, because it displaces that framework and significantly changes it. It applies the standard that usually applies before an actual court, which is the housing standard again. And the distinction is, right, not for issues of fact, because they're reviewed under a similar standard. More interventionist, though. Palpable and overriding error arguably is a bit more interventionist than reasonableness review, but similar standard. Questions of mixed fact and law, same thing. But issues of law, as we will see, pursuant to the housing framework, are reviewed with a standard of correctness, period. Any issue of law, not just the big ones, the important ones, any issue of law is subject to correctness review. And that's where the big difference comes in. It's why the magic word appeal is extremely important, and it's how you have a standard that's markedly different in that it's far more interventionist and specifically for issues of law, as we'll see in a later capsule on the housing framework. So as I said, we're finishing up for this week. The standard of review, finally, right, should be pretty clear. If you are finding that the stuff for this week and last week is getting redundant, that's not the case for everyone in this class. Count yourself lucky, right? Nonetheless, it's the last week that we look at that, so it won't be redundant anymore. But if it's getting clear, it's probably because I did my job right earlier in the semester, trying to have you understand, right, what correctness and reasonableness review means, although we did not specifically cover it at the beginning of the semester. And I don't think it's supposed to be that easy. So hopefully, if it's getting redundant, you should be very, very happy about that. And next week, right, preview that, also something that's important, but we'll mention it because we didn't cover it in as much detail as we did the stuff for the standard of review earlier in the term, and that is remedies. And as we'll see next week, the default remedy is something we discussed already, is to quash the decision and return it to the decision maker for redetermination. So, and that is true, quite important to stress already, right? Note it down now, not just next week. It's extremely important. It's regardless of the standard of review that applies. So, deciding whether or not you have correctness review or reasonableness review is important insofar as it determines the way in which you assess an issue. So, it's also why, by the way, you have to determine it first, right? You have to decide whether it's an issue of, say, procedural fairness, discretion, before you look at the actual issue, right? Before you look at even the claims of the parties in any more detail than has been asserted, you have to pick the standard of review because, of course, the standard of review is the way in which you will then assess the issue that's before you as a decision maker. It's the way in which you'll determine whether or not there is an issue as it is being raised. After that, after you've done that, pursuant to either correctness or reasonableness review, the nature of the standard of review that has been selected and applied loses its relevance. Meaning that the remedy is the same. So regardless of whether an issue makes a decision unreasonable or incorrect, what you do with it afterwards to correct the problem is the same. And by default, there's a bunch of remedies, especially before the federal court. There's a laundry list, as we'll see. But the default remedy is you quash the decision and return it for redetermination. Even if it's incorrect, even if it's an obvious issue. And it becomes important when it's incorrect because you know the actual answer, right? The nature of correctness review is, right, you reassess the issue and decide what you would have decided. If it's not the same thing, it's incorrect. So you know how to correct a decision, to make it correct relatively simply, in a way that you don't under reasonableness review. Nonetheless, you don't do that. You apply, regardless of the standard of review, the same remedy, which by default is to quash the decision and return it for redetermination. What does that mean? We'll see next week, right? Quash means cancel. You cancel the decision because it's wrong, right? Incorrect or unreasonable. And then instead of yourself changing that decision, as say a court might upon appeal, you send it back to the decision maker for redetermination, which is obviously a recognition of the deference, specialized expertise, all the stuff that we saw. It would not be consistent with saying that the decision maker has a unique expertise and is owed deference if, right, a court could just change the decision even when it knows what the correct decision or the reasonable decision would have been. So quash it, cancel it, send it back for redetermination. Usually that will mean by a different actual decision maker, right? So obviously you send it to the same tribunal. Usually the rules would bar the same actual person from making the decision, right? For obvious reasons, right? First, they got it wrong the first time, and second, they've just been told they're wrong, so they might be unhappy, right? So you give it to someone else. So, review of the standard for this week. First, right, we have the presumption of reasonableness review under Vavilov. Won't repeat that again. Then you have the link between, right, the rationality of a decision, which ends up being a bit circular, right, tautologous, as the Supreme Court says, but it's kind of an interesting way to understand it. So a decision that's unreasonable may be irrational, okay? Irrational means it doesn't make any logical sense. So you come to a result that simply does not make sense from the premise. So you say, this is true, right? X is true because Y. Well, Y clearly does not and cannot make X true. But it need not be irrational. It might be something else, right? So you can have a decision that's rational, right? So for example, the face of the decision as rendered, right, says this is true because that makes sense. It can flow from the premise. Nonetheless, from the record, it will become unreasonable because the assumptions being made there are just wrong, right? And even though it's logical, even though it makes sense, even though it flows, right? Even though the decision in itself is something that you can follow logically, it is not supported by the record at all. It's not a possible interpretation, again, within the range of possible interpretations that you can have, and therefore, right, it will become unreasonable, although it is rational. Okay, some of the stuff that we saw last week bears repeating, right? First, you look at both the reasoning process and the outcome. So, that's important. It's a change of prior case law that developed before Vavilov and within Vavilov. So, when there's an outcome that makes sense, that is not sufficient. So, the outcome, even if it makes sense, has to be supported by the reasoning, otherwise the outcome will not be, right, retroactively, quote unquote, or alternatively justified by the court. So we discussed that last week, so that's why you look at both, right, the reasoning and the outcome. To the extent that there are reasons for the decision. As we said, won't repeat it 20 times, right, but there need not be reasons for the decision at all. When there are, they might look whichever way the decision maker wants them to look, and that might be appropriate. However, when there are reasons, that's what you start with. And in fact, generally, it's what you end with, right? To the extent you can follow within the decision and it's supported by what you had before the decision maker, right? Cites the record, all that. It's where you start, because Vavilov says you have to start with the reasons if there are any. And it's where you stop to the extent it's sufficient for you to assess the reasonability of a decision. Okay. Still page 527. Again, some of the magic words. So 527, review, it's important, right? Some of the magic words in Vavilov, which are actually quoted from Dunsmuir, but that's important. So the three main hallmarks, quote unquote, within Vavilov are justification, transparency, and intelligibility. So these are three very important, most important magic words in assessing the reasonableness of a decision. Justification means, right, it's no longer sufficient to have a proper outcome. It has to flow from the premise, right? And you have to adequately explain how it flows from the premise. And that's where you get to transparency and intelligibility. So, right, the decision has to flow from what you start with, and it has to be clear how it flows from what you start with. And it often, right, but not always, has to be clear on the face of the decision with the reasons how it does that. Okay. Reasonableness does not require perfection, that is mentioned in Vavilov. And there's another magic phrase that says, right, you don't get into a line-by-line treasure hunt. What does that mean, right? Well, it means that the parties will always say that it's unreasonable. And oftentimes the parties will say that you have ignored an important issue or piece of evidence. As you can imagine, though, the nature of administrative decision-making is that you might have, right, 2,000 documents before you. And of course, the expectation will not be that you specifically deal with the 2,000 documents, and especially not to say, right, this is not probative, right, it's not good evidence, doesn't convince me because X, and do that with every single piece of evidence. It would be, right, prohibitively time-consuming and frankly useless, right, because then other issues would arise as to whether each of these decisions is reasonable, and on top of that, right, probably doesn't help to specifically, right, get away from evidence that's not particularly relevant. So that's what we mean by line treasure hunt, right? And that's especially true given that the nature of administrative decision making will usually be that the decisions are shorter, they are given more summarily, and usually with a bit less care than a judge would because of the significant caseload of the administrative decision maker. That's allowed, and that's why we don't expect perfection, and in fact expect it much less than we would from a court. Nonetheless, the important thing gets back to the factual and legal constraints, the 14 or so things that we saw 2 weeks ago, or last week, 2 weeks ago, right? So if it's important, it has to be addressed, because then it's essentially a matter of procedural fairness or the rule of law. So all the important issues have to be addressed. Obviously, if there's 5, usually the 5 will be important to address, right? So unless there's 20, means what it says. And same thing for the evidence, right? Evidence that might have changed the decision, right? Big evidence that would otherwise change the nature of the reasoning process that will have to be specifically, right, moved away from with a justification. So, again, important issues, important pieces of evidence have to be specifically addressed. Otherwise, there's a default presumption that, right, there's no line-by-line treasure hunt and that you're not expecting perfection. Okay, 529, the standard of reasonableness review does not exist on a spectrum, right? It's something that lots of people speculate about, including me, I think, earlier in the term, right? In that most things are subject to reasonableness review, But obviously, a court, although it is notionally applying reasonableness review, will be more concerned about something big, right? Like procedural fairness or jurisdiction. So, in conducting reasonableness review, the court might be more careful, right? More attentive to potential issues. Nonetheless, under the framework, there is no such thing, right? It's something we can speculate about, but there's no such thing. There's two standards. There's correctness and reasonableness review. Obviously, reasonableness review will apply most of the time, even more so with Vavilov. But once you fall within that, the nature of the issue does not change the nature of the review. There's no multiple reasonableness ways to conduct reasonableness review, right? There's a single one, and it's applied consistently. At least that's the notion that we're expected to believe from the Vavilov framework. Okay, and reasonableness review, right, 530, 531, you have examples of that. You've had examples of that throughout the semester. Certainly, it is correct to say that most of the time it will have the decision confirmed because of how much deference is owed, because of the nature of the standard, which says that you have multiple possible outcomes, right? That makes it likely that the decision will be one of these possible outcomes, and certainly far more likely than when you have, right, correctness review. So, most of the time, yes, the decision will be confirmed. Nonetheless, doesn't mean that reasonableness review is rubber stamping. You have to conduct review, and if you don't have the material to do so, there's no reasons. You'll have to get into the record, right? It's not reasonable because of the outcome only. It's not reasonable because, right, it seems like it makes sense. You might have to get very deep and do what the Supreme Court calls, right, perhaps correctly, a somewhat probing analysis. So it doesn't mean that there's no review, and it's an exercise in itself that can and does, right, sometimes, not always, but sometimes, maybe often, right, lead to a decision being invalidated because it's unreasonable. Okay, then you have a discussion of the federal court. Somewhat important because it changes a bunch of things, right? Usually, as we said, pursuant to the Constitution, the default court of constitutional jurisdiction is the superior court, as we said, right? Won't repeat that again for all the reasons we mentioned early in the term. It's where you go because it's a court of inherent jurisdiction, right? It's the default place you go. So you go there a lot of the time because you go there whenever there's no law that says you have to go somewhere else. Well, one of the laws that says you have to go somewhere else is the Federal Courts Act. So the federal court is and we saw the federal court earlier in the term, if you want to look at your notes, right, in some detail, but not this part. So federal court is a court of statutory jurisdiction, not constitutional jurisdiction. Why? Because it's not created by the Constitution, it's created by a law. And that law is the Federal Courts Act. So, Federal Courts Act creates the federal court, right? That's allowed if it's not taking away stuff at Confederation, blah, 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 all right? All the stuff we saw earlier in the term. And, right, the federal court derives its authority solely from the statute. So there's no inherent jurisdiction. There's no, this looks federal, so it goes to the federal court. It doesn't work that way. It's the specifically enumerated areas of law which are subjected to the federal court, right, which are there, and it's exhaustive. There's no default, there's no interpretation, right? It's in the list. If it's not, it's the default court, which is the superior court. Usually deals with, right, some intellectual property issues, immigration issues quite a bit, and the government, and the federal government. Right? And that's why it's going to have a very significant administrative law jurisdiction. First, because the other things that it does, right, are administrative in nature. So I just said intellectual property will sometimes, right, some administrative body like the board, right, the copyright board might make a decision, then that's reviewable by either the federal court or federal court of appeal, right? Although that's intellectual property, which is a shared jurisdiction actually, for reasons we won't get at, having to do with damages, or whether you're getting damages or something else, right? But it's essentially administrative in nature. Same thing for immigration. You'll recall we said there's specific tribunals to deal with immigration issues that are administrative. So you've got the Refugee Board and you've got the Immigration Board, each of which have an appeal division. And then you go to the federal court, and as we said, right, because you have an internal administrative appeal before one of these appeal boards, the federal court shows further deference because you've already got a chance to have it done over entirely within the administrative system. The federal court shows deference, and so you have to ask for leave to seek judicial review, so leave being permission, like the Supreme Court, to seek judicial review before the federal court. So immigration, also administrative, and it deals with the federal government, and that's administrative. Almost all of the decisions that will be made by the federal government, right, which is an administrative system, right, so say the minister, the bureaucrats, everyone, right, these are generally administrative decisions, and these are generally reviewed by the federal court. 18.1, paragraph 4, page 534, notionally there's a different standard, which says that issues of fact are only reviewed if they were made in a perverse and capricious manner or without regard to the material before the decision maker. And that's important, right, to the extent that on the exam say you might get something that falls within the jurisdiction of the federal court, or the general principles of federal court as we saw them earlier in the term, obviously not stuff that we didn't see. Okay, so technically that standard appears to be more stringent, because it's got more adjectives in it, than correctness review. So it would suggest that issues of fact, right, which otherwise are subject to reasonableness review, right, sorry, I think I misspoke there. Standard appears to be more stringent than reasonableness review because it's got more adjectives in it, right? It doesn't just say unreasonable, it says perverse or capricious, okay? This changes, ostensibly, the standard for issues of fact only, which would otherwise be reasonableness review. Nonetheless, as is discussed at pages 534 and following, the federal court essentially ignores that, right? It ignores that by saying that, by first generally not really applying that standard or not even naming that standard, but even where it applies, right, it's considered to be a spectrum precisely because the federal court has such broad and diverse jurisdiction in the way I've just described, right, on a bunch of very different things. Because of that, right, the federal court will say these adjectives are meant to describe not one standard for issues of fact, but a broad range of standards that can apply depending on the nature of the issue that is before the federal court, subject to judicial review. Okay, page 538, you have a discussion of discretion, which is something that we discussed quite a bit in previous weeks, won't get back to. But importantly, right, you're mentioned that there's no such thing as a discretionary decision anymore, right? We saw that under the general framework, under Vavilov, right? And that's generally because discretion would tend to heighten the deference being owed, which is already at its notionally highest standpoint, right? Because there's a presumption of reasonableness review, which applies to everything. That would include discretionary decisions. A discretionary decision normally, right, you give more power to the decision maker. That suggests that you don't want the courts to intervene, right? Because by default, there's reasonableness review. There's a range of possible outcomes. Now you say on top of that, right, I'm giving you further power to have a broader range of outcomes or no outcome at all. Just sit there and decide that power isn't exercised as discretion. So it heightens the deference, right? It makes it even more likely to be subject to reasonableness review. So obviously it's not particularly useful because it's no longer a separate category, right? There's already a presumption of reasonableness review, and notionally, as I just mentioned, you can't get higher than reasonableness review. Nonetheless, it's helpful in, right, certainly making sure that for that specific issue, for sure the government intended for reasonableness review to apply. And as we saw, and as is specifically mentioned there, it's not always clear whether an issue is discretionary, and sometimes it's best understood as falling within a spectrum, right? A spectrum of more or less discretionary decisions, and these will, again, heighten the deference being owed, or at least the indication of the government intent to heighten the standard to an extent that's proportionate with, right, the more or less discretionary nature of the decision. Okay. Then you have discussion pages 553 and following of the old standard of review. First, there's a thing called patent unreasonableness, right, which I said I actually did my best not to have you learn, right, because it's already confusing enough, right? First, there's, it's probably the only second-year course where we can't actually tell you what the law is, right? And in fact, it's the very nature of administrative law. There's no actual clear answer. That's actually how it works, right? So that's hard to start with. On top of that, for the reasons we mentioned multiple times, the way the book is conceived, which I fully endorse, right, doesn't even teach you about the standard of review until the very end, right? It goes more chronologically, but still it's kind of the assumed big thing that you'll have to learn about, because what you actually do as a lawyer is go before a court, right? So it's assumed throughout, right? So on top of that, if you had a third standard, which no longer applies and which was never even clear to start with, it would be way too much, I think. And that's why we have been very careful. I have been, not sure why I'm speaking in the plural there, I have been very careful to remove it, right? Sometimes it meant removing 4 pages from your readings consecutively, so you didn't have to see it. I said, if you read it, plug your ears, right? We won't learn about it. Well, we'll talk about it now a bit, because it's somewhat helpful once you have an actual deep, hopefully, and thorough understanding of unreasonableness. So, it used to be an old standard, or it is an old standard. It used to apply where you had even more deference than reasonableness review. Kind of like the stuff that we see still, right? Fully discretionary decisions, these would attract a very strong presumption of reasonableness review, right? And in fact, in conducting reasonableness review would be very likely to be confirmed because of that, right? So, kind of the same thing, right? Normally, or formerly, these would be the kind of issues where it's really clear that there's lots of deference to be owed. The government has, or say privative clause, same thing, right? Government has, right, been doing everything it can to show the clearest possible intent for deference to apply. This is the kind of place where it would apply. And essentially, it said, right, it had to be a mistake that you cannot miss, that jumps at you, right? Even worse than palpable and overriding error, right? Which has been defined as, right, the tree has to fall, not just the leaves or the branches, right? It has to violently jump at you and be extremely clear, and that's where you get to the discussion of rationality, which got very confusing, precisely because it seemed to be tautologous for the reasons that are mentioned there. So, when it jumped at you, when it was obvious, when it was a clear issue of logic, right, when it was clear from the face of the decision, without getting to the record, without getting to the actual exercise, as we've just described it quite a bit, of reasonableness review, of going deeper and deeper, right? When you didn't even have to do that, it would be labeled as patently unreasonable. Obviously, right, the nature of that is that it's not actually clear, it's somewhat subjective, and in fact seems to move away sometimes from its notional definition of something being irrational or unclear. So, no longer applies, was collapsed into the reasonableness standard, but still, right, is somewhat not relevant, but analogous to other things we saw, to other ways in which the government can not heighten the nature of deference that's owed, but certainly heighten its indication that deference is to be owed. Show it very, very clearly for the court not to mistake it, for instance, with, as I said, right, very discretionary power or privative clauses, which will say this decision is, say, quote unquote, fully final and without appeal. That being, as we said, the permutation of a privative clause that is the most indicative of a government intent for the court not to intervene. Okay. Then there's a discussion of a proportionality test as a potential alternative to the issues that we saw. Obviously not doctrinally important, say, for the exam, but somewhat interesting, right? It's a different way to assess it, and it's precisely what we use in Canada for assessing constitutional rights, and therefore bears obvious relevance because it's public law, and it's a way to defer to the government, right? So the Charter protects some extremely important rights, right? Extremely, extremely important rights, right? Otherwise it wouldn't be there, like freedom of religion, freedom of expression, right to life, right? Not getting killed by the government. That seems pretty important, right? Nonetheless, all of these rights, I'm actually lying for reasons that you might recall from constitutional law, but almost all, so say all these rights, right, there's a mechanism in Section 1 that can limit them. Some of them have a further limit, like Section 7 has an internal limit, as we said. The principles of fundamental justice, these can limit your right to life. In other words, can allow the government to infringe upon it. Well, even when there isn't that, say Section 2, there's Section 1, which says, essentially, the government can infringe upon that right if it has a good reason. That's what Section 1 says. And Section 1, through the Oakes test, looks at the reason, looks at whether it's a good reason, and then essentially looks at whether it's worth it. So and that's obviously much simpler than what they probably told you last year, but it's essentially the nature of the Oakes test, right? So it looks at the government purpose, what it's trying to do, the reason for infringing upon constitutional rights. And then it essentially weighs that against the constitutional infringement to see whether it's worth it. And that's why, right, you have gross disproportionality. Well, that just says it's clearly not worth it because it's infringing too much, right? And same thing for the other factors that you have under the Oakes test. Well, that's a way to assess, right, the legitimacy of the decision, and you could have that with administrative law as is being described there. It bears some resemblance in its result as reasonableness review, in that it will often confirm a decision. And you see that, right? Almost all breaches of Section 2 will be confirmed. Section 2B will be confirmed by the courts pursuant to Section 1. Most Section 7 breaches, same thing, right? So the purpose can make sense, right? It's not because you have constitutional rights, which are really important because they can trump any law. It's not because you have that, right, that the government won't get to do it anyway. However, it is more interventionist in that it requires the comparison, between the two, I think, is helpful in understanding the nature of reasonableness review. It's more interventionist in that it looks at the substance of the decision more, because it requires an assessment of why a decision was made, and then whether or not it's worth it depending on its impact, right? Both of which are within that framework. We talked about the impact, we talked about, right, weighing policy concerns. We said if there's a multiplicity of policy concerns, a quote polycentric decision, then there's more definitely. So all these things are within reasonableness review anyway, just not in the same way, right? So it requires greater intervention because it assesses, right? It assesses these issues, and to do that has to look at the substance of the decision in ways it's different from reasonableness review. There's no way to just from the face of a decision confirm it with that kind of review. and oftentimes, as you're mentioned, it's actually subject to additional deference, which is not inherent to proportionality, not inherent to the Oakes test, which doesn't necessarily have differing levels or intensity of deference, right? And in the administrative context in Europe, right, that allows for similar deference in what you have pursuant to reasonableness review. So if it's a decision that is more discretionary, that's more policy-oriented, right, in conducting the exercise under proportionality, you will defer to a greater extent to the decision maker, which will essentially, right, lead to a similar result, if not a similar process, than you'd have under reasonableness review. And we will pause there for our discussion of the standard of review prior to the housing case.